Alrighty, so this is Decent Weed People News. Okay, I'm gonna stand on the video of a UCC 1-308. All rights reserved. Okay, I'm not gonna waive any of my rights, people. Alrighty, I'm not an attorney. I'm not giving legal advice. However, I will give an opinion, and my opinion only. Okay, so do not construe it of anything, shape, or fashion that this is legal advice. Okay. Do your research if you decide to follow through with what I say. But you got to be responsible for yourselves, and too many people are actually banking on other people way too much. These people right here is willing to take the consequences, because when you actually go in court without attorney, they can, out of retaliation, the judge will give you the full sentence because you never agreed to their terms and pleading. Okay, so they just hate people standing up for their rights.
You get my notice?
Your notice, sir?
I'm not a sir. Can I have a seat?
Have a seat, please.
Okay, just a second. She'll say, yeah, she got the court's notice and all that, but was that or was not a hesitation, right? She's going to claim that she basically went through the notices. The courts actually have it. But she's kind of like, well, notices? You know? And then said, sir. All right. Sir is a title. He's not going to, he's a man. He's not going to be a title. And these courts love to bound you into a title. If you're listening to some of these videos, wink wink, sovereign citizen crap, alright, they are using titles and they just cannot get away from sir, mister, this, that, here, and there. They can never call a man by his name. Why is that, y'all? Y'all think about that. Why can't the courts call each and every individual that goes in that court by their name? Mr., sir, ma'am, Mrs. is not a name. It's not on their birth certificate. All right.
Did you get my notice?
Your motions that you filed, your notices that you filed, yes, the court has reviewed them. I'm calling court case 19 CM 1570. State of Wisconsin versus Ryan Robert Desmith. He is appearing in person without counsel. Assistant District Attorney Hannah Schuckert is appearing for the state. This is an initial appearance, and we're here today. Sir, have you received a copy of the criminal complaint?
I stand on my notice.
Did you receive a copy of the criminal complaint?
I stand on my notice.
Sir, it'll go a lot easier if you just answer the question.
There you go, y'all. Bailiff actually says this will go a lot easier if you just comply, right? But what she is doing is having him waive his Fifth Amendment to incriminate himself. Anytime the courts ask you any questions while you're in court, it is an incrimination. Whether it's good or bad, it's still an incrimination, y'all. Okay? This whole thing is supposed to be the prosecutor proving the burdens, right? He's just supposed to sit there and listen. Okay? And then they can comply with it, or, you know, ask questions back. Alrighty? And try to never argue.
You got my notice.
Did you receive a copy of the criminal complaint, sir? This is a very simple question. I called other cases before you so that you could understand how the court process is proceeding. This is a very simple question. You were sent a criminal complaint and a summons, and you are being charged with carrying a concealed weapon, party to a crime. That is a Class A misdemeanor. If you are convicted of that crime, you could be fined not more than $10,000 and imprisoned not more than 9 months. Count 2 is obstructing an officer, party to a crime. If you are convicted of that, that is a Class A misdemeanor. You could be fined up to $10,000 and imprisoned not more than 9 months. You are also being charged with disorderly conduct, party to a crime. That is a Class B misdemeanor. If you are convicted of that, you could be fined not more than $1,000 or imprisoned not more than 90 days. Now, knowing what you've been charged with and the maximum penalties, you have certain rights. One of those rights is for the state to prove these allegations against you in a court of law. You are also entitled...
Okay, right there, people. The state has to prove him guilty. She at least was honest about that, but they don't really do that. They go by assumptions and presumptions, right? The state's over there, and the other side over there, all she is going by is hearsay from what everybody else said what this man did, right? But that prosecutor over there has no first-hand knowledge. The state has no first-hand knowledge. Okay? So everything in there is going by hearsay.
to have a court trial or a jury trial. That is of your choice. You are also entitled to having an attorney represent you. If you are not working, you can apply to the...
You notice right there, right? She says that he has a title to attorney, right? Not a right. Not a right, but a title. He has a title to have attorney. Now, he has a right to counsel, but he does not have a right to a lawyer. Two different things, y'all. Research it.
state public defender, and then an attorney can be appointed for you. If you do not qualify for the state public defender, you have several other options. One of those options is to defend yourself. Another option is to hire an attorney. If you call around and realize that you cannot make the retainer to hire an attorney, you can then come back to court and fill out a form for a court-appointed attorney. The county would then appoint you an attorney if you qualified, and then you would be responsible for paying back the county on a monthly basis for the attorney. Now, those are your rights, sir. This is the purpose of today's hearing. So, I need to know, do you plan on hiring an attorney?
I don't understand what you're saying. I don't speak your language, I only speak man to man.
Okay, the short version, if I can do it, right? He don't understand because she is sitting there speaking babble, right? All these lawyer words that came from other country that integrated into our system, all right? Signs of acquiescence and this, that, here, and there. Tacit agreement, all these things, okay? But he just wants to set this in a common law area and be able to face his accuser, not this judge.
Okay.
You got my notices?
Sir, those notices can be addressed upstairs in circuit court. At this point, I've told you the purposes of today's hearing. So, I'm going to enter not guilty pleas on your behalf.
If you enter a plea on my behalf, you will be held fully liable.
And you will have these cases, we will be then sending this case upstairs.
Okay, see what just happened? You may have to rewind it, right? That attorney did a little bit of a nod to him to call down to security, right? Because this man is not complying to answering and violating his Fifth Amendment. But she is bound and determined for him to violate or waive, not violate, but waive his Fifth Amendment. He is standing on the Fifth Amendment, y'all. But that judge cannot stand us men and women standing up and standing on our rights. They just can't stand it. All right, so we'll proceed forward on this.
This is going to branch A with Judge Lee Joyce. Now, before I enter that on your behalf, you do have a right to substitution. Do you have a...
Oh, I just remembered the other part, right? He actually made a contract, y'all, believe it or not. Okay? Well, when she said that right there, that I went blank. But when she said that she's going to make a plea for him, he said, well, you're going to be held responsible for that plea because they technically cannot do that. She is now become his attorney by doing so. All right? Most people don't realize these things. But, she is a bar member. She's a bar member. Okay? What she did right there is actually made a plea for him and act as his attorney. And now he's saying you are responsible for the action. He made a contract. And as she proceeds forward, she, right there, tacitly agreed to his terms. Or she stayed in silence with acquiescence and agreed to his terms. However, it's more along the line, since this is a business, she tacitly agreed to his terms. They have a contract right now.
problem with Judge Lee Joyce hearing your case?
Who are you?
I am the court commissioner. I'm in charge of hearing this introductory hearing in the court. I'm asking you, do you have a problem with Judge Lee Joyce hearing your case?
Who are you?
Why don't you just answer the question, sir?
So Roberto,
There we go again, right? That bailiff is saying, hey, waive your Fifth Amendment. Okay? But did that judge ever give him her credentials? Does he know with first-hand knowledge of that she signed the correct oath of office? It's just a question, y'all.
I have time for this. I have a courtroom full of people.
I'm not a servant.
He's not a title. And he's standing on that.
Mr. Ryan Desmith,
Yes, I'm man.
I'm asking you a very simple question. Do you have a problem with Branch 8, Judge Lee Joyce hearing your case?
Whose court is this?
Would you like me to schedule, Commissioner?
Yes.
Okay. Now, since they entered a contract, when he said, whose court is this? She, by silence acquiescence, are basically saying it's his court, which actually would be true. It's his court.
January 27th at 9 o'clock.
That will be your next hearing. It'll be upstairs in front of Judge Lee Joyce. The court has entered a not guilty plea on your behalf. And what is the state's request for bond?
There we go. So she signed a contract with him. Verbally. Okay? So, if in fact he knows how to do his notices and remedies correctly, then he can go after her because she stepped out of her constitutional duties.
State's recommending a $2,500 signature bond. Conditions to be no contact with the property That is the Assembly of God Church. We're also asking for no possession of dangerous weapons.
Was there cash posted in this case?
Let me check.
Whose court is this?
I don't see that cash was posted, Commissioner.
Court will issue a $2,500 signature bond. Also, no contact with, this is the Assembly of God
Correct,
Church.
correct.
And also, no possession of any weapons. You can come forward, sir. Sign your bond.
I stand on my notice.
Sir, come on up. We don't have time for this. Come on up.
I'm not a sir.
Either sign this or we're gonna remove it as refused.
I deny service.
Okay. Refused, and then you can leave.
Refuse, and then you can leave. Okay. Number one, I don't know if I would quite do that. I probably would just tell them that I'm not going to engage in y'all's criminal activities. You know, I'm not going to waive my rights. All right. And the way they're doing it and all that, they may already put in his notice of challenging jurisdiction. Okay? Which that judge has not actually gave the correct jurisdiction, or if she ever did. Okay, in this video she didn't do it, but she, by the what we have first-hand knowledge of right now, he's never challenged jurisdiction.
Okay, you're done here.
Goodbye. Jordan Thomas Salmi. This is 19 CM 1571, State of Wisconsin versus Jordan Thomas Salmi.
Have a seat, sir.
I'm not a sir.
Have a seat.
Let it be known this day,
Have a seat.
for I, man Jordan Salmi, am in a state of man, now passing forthwith. I'm not a
me
respondent
take him
or
in.
defendant.
You can leave.
See right there, he's just letting the courts know he's not a defendant or respondent. Okay, he's not defending himself. Plaintiff, defendant. He's not claiming any one of these. He's just letting them know he's not either one. All right. So this whole court system right here is designed for you to give up your Fifth Amendment rights and give them all the information. And every time you speak to them and answer their questions, you are in fact making claims. They made a claim on them too. But what happened is when you answer their questions, now you're making claims. So the burden of proof is flipped. It's the trick, right? You made the claims, so now they tricked you into being a claimant. Even though they say it's a plaintiff and a defendant, what they just did, or tried to do with these two, right, is flip them making a claim to these two people to make a claim. That's the reason why you're guilty before innocent, because most of us go in court and we actually make these claims. Every time they ask a question, we're making a claim. My opinion. I'm not an attorney, y'all. Verify everything I say with an attorney. Wink, wink, wink.
I'm asking you to leave. Is that an order? Leave, please.
Is that an order?
Excuse me?
Is that an order?
Yes.
All right there. He kept on asked twice for him to go. Twice he says, is that an order? He finally, the bailiff finally said, yes, it's an order. Okay? The reason why, y'all, if you walked out before that, then they can go after him for leaving the courtroom. Right? But now, since it's an order, the burden of proof is back on this court building. It's back on these people, the bailiff, the judge, and all that. Why? because he was ordered to leave. That's why. That's the reason why he didn't leave when they asked him twice. He, the officer, if he knew better, he would have said it 3 times. You know, but that being said, he wasn't going to have it. He was not going to leave until there was an order to clear him, because they can go after him, and I'm assuming that they already called the bailiff downstairs to maybe come after these people. I don't know, but if that's the case, the first thing they need to do when they come up to him, don't you trespass upon me, right? And then they need to say it 2 more times. Don't you trespass upon me. Do not trespass upon me. Right? Most cops know about trespass. Anyway, this is Diesel Weed People News. So they can get that officers for being in trouble for trespassing against him if they're in fact downstairs waiting for them. And in fact, there's witnesses there, the courts. Again, y'all, this is just my opinion, okay? I'm thinking outside the box. I'm tired of this court building raping us, right? They take everything from us. Now, if these people, in fact, created a victim, then we have a problem, and they're not going to be set free no matter what. I can't say that, but you know, sometimes these people is too much of a headache. If I ever get time, I may look up these numbers and see about the case law on this. But chances are, since it's standing up as a man, it's going to disappear. You're not going to be able to find it, because they cannot have people reading it, understand what's going on, and redoing it and using it, and actually stand on their inalienable rights. Okay, so that's what I'm seeing right at this point in time. If I actually look up at it, it's probably going to be gone. But that's just my opinion. I do not have no facts on that because I never looked it up, y'all. If you guys are brighter than I am, go ahead and try to look it up and see what you guys come up with, because I'm kind of curious how this ended up. Alrighty. And I guess you can kind of see over there, off-grid victory. I think he just found this too, and he recorded it. So I don't know who the original recorder was. All right, Diesel Weed People News. Bye, y'all.